Welcome to Rebel Chaser. My name is Gail, and I've got a video for you from Judge Thornton in North Dakota. And this was actually done the day before Thanksgiving. So I'll let you guys watch.
All right, Richland County District Court is now in session. This November 26, 2025. My name is Nick Thornton. I'm a district court judge for the Southeast Judicial District, which includes Richland County. Based on the court's other business, I'm sitting in my home chambers in Barnes County. This matter is venued in Richland County. This is an emergency hearing under Rule 8.2 of the North Dakota Rules of Court in Mullen versus Mullen, 39-2024 DM27. In this case, Attorney Tracy Lindberg appears on behalf of Plaintiff Nicholas Mullen. Mr. Mullen appears from a different location than his attorney. Danielle Mullen does not appear, nor does her attorney Samuel Johnson. We are live streaming today's event on the Southeast Judicial District's live stream YouTube channel. These are open and public proceedings. Any member of the public can attend in person in Richland County in that courthouse, the Barnes County Courthouse, or by following along on the live stream YouTube channel. Again, this is an emergency hearing. Under the rule, the court requires, or the law requires, that before considering an emergency ex parte interim motion, the court must first attempt, and it says attempt, to hold an emergency hearing either in person or by telephonic conference, at which time both parties may be heard before issuing any order. Under North Dakota Rule of Court 8.2A4. In this case, there was a judgment entered by stipulation. That judgment was entered, marital termination agreement was entered on September 5, 2024, Record Index 17. Attorney Johnson filed proposed findings of fact, conclusions of law, and order for judgment, Record Index 22, and a proposed judgment. Because the court believed that the parties had worked out all of the technical issues on that document, the court, about a week later, signed an order for findings of fact, conclusions of law, and order for judgment, Record Index 25, and judgment, Record Index 26. A few months later, the court received a motion to amend the judgment. Ultimately, the court entered an amended findings of fact, conclusions of law and order for judgment, Record Index 33 on October 25, 2024, and a consistent amended judgment. Then, about 2 weeks ago, the court received another motion by Danielle Mullen seeking to amend paragraph 8 of the amended judgment and decree concerning child support. That motion is still pending. And then about 2 weeks later, the court received an expedited motion for ex parte order. That motion is Record Index 54. That was filed on November 20, 2025. In it, Danielle Mullen seeks sole primary residential responsibility and sole decision-making responsibility on a temporary basis to suspend Nicholas Mullins' parenting time pending the completion of another chemical dependency evaluation, and thereafter, looks like graduated parenting time following a host of conditions, plus attorney's fees. That motion wasn't detailed to the court. So again, I'm required to have an emergency hearing. Usually I do try to have those emergency hearings within 24 hours. I didn't find out about that motion until this morning. When I found out about that motion, it was this morning when Mr. Johnson sent an email to my court recorder asking about the status of the case. I don't ordinarily sit in Richland County, and so it appears as though it was detailed to Judge Cruff. Judge Cruff is out of the office. It was detailed to Judge Cruff, even though the case was assigned to me, I think in response to what do we do about the motions to amend, although it's not clear to me. Bottom line is I didn't know about the motion until just today. And then I tried to get this set up as quickly as possible. And again, the rule says I have to attempt to have a conference. It doesn't mean that I actually have to hold it, but I have to attempt to have a conference before issuing an order. The court did receive an email. Ms. Strom attempted to arrange the hearing, this emergency hearing. Ms. Strom sent an email today at 11:14 a.m. to the parties. In it, Ms. Strom indicated with defendant's expedited motion for ex parte order under Rule 8.2A4, the court must attempt to hold an emergency hearing. This hearing will be held today. Hearing will be held at 2:30 p.m. today, November 26th, or as soon thereafter as the matter may be heard. We have a guardianship hearing at 2 p.m. Thank you, Lori Strom. Ms. Lindberg responded, will this be held by Zoom? Ms. Strom responded, I apologize for not stating that. Yes, I will be filing a notice of hearing shortly. And then she provided the Zoom meeting ID and passcode. Mr. Johnson sent an email response at 12:21 p.m. today. Mr. Johnson emailed Ms. Strom and copied Ms. Lindberg and others. Good afternoon. I have a custody trial this afternoon commencing at 1:30 in file number 26 FA 2084 out of Grant County, Minnesota. So I'm not sure how long that hearing will take. It may be the entire afternoon or only a couple of hours. I'm not sure at this time, so not sure what to do here. Just want to let everyone know that I will not be available at 2:30 p.m. today. Look forward to hearing from you in this regard. Signed, Sam Johnson. I am inclined to do one of three things. Again, Mr. Johnson does not appear. His client does not appear. Ms. Lindberg appears. Ms. Lindberg's client appears. Ms. Lindberg did file a written response opposing the ex parte emergency interim relief order. There are declarations and counter declarations that have been filed in support and in opposition of the motion. Again, the rule says I have to consider whether, or at least attempt to have an emergency hearing. I have attempted to hold the emergency hearing as soon as I became aware of it. Although Mr. Johnson is not here to articulate his client's position, ordinarily, I would give an opportunity to the plaintiff or I shouldn't say plaintiff, the movant to articulate their position. And most of the time I can get a hold of the movant, but not the non-moving responding party. And that's the exact opposite here. So ordinarily, if I can't get a hold of the movant, I would often attempt to reschedule the emergency hearing. I struggle with doing that in this case for a couple of reasons. One, it's already 6 days after the motion was filed, so it arguably isn't an emergency anymore. Two, if I continue the hearing, usually I continue it less than 24 hours, but today is the Wednesday before Thanksgiving holiday. And on Friday, my court staff has already been approved for leave, which means that I probably wouldn't be able to continue the hearing, even though I'm going to be working on Friday. I don't have a court recorder to record the proceedings, so I can't hold the hearing on Friday. I'm not holding it tomorrow on Thursday, Thanksgiving. So that leaves us continuing the hearing until next week, if I continue the matter at all. Otherwise, I could simply rule on the motion based on what's in front of me in the declarations. The court notes several of the declarations are replete with hearsay, and there is a requirement by declaration that the declaration be brought and be competent. There's case law suggesting that a competent affidavit or declaration is one that involves firsthand knowledge. Here there is a lot of secondhand knowledge and or hearsay and or speculation contained throughout these declarations. So the court, again, I don't have a party here to articulate the positions, but I would typically exclude those hearsay statements, but I would normally have parties here to walk through and parse through those affidavits to make the arguments instead of me ferreting out what's hearsay and what isn't hearsay, and what is firsthand knowledge and what is not firsthand knowledge. So I'm in a pickle. Ms. Lindberg, what's your position?
My position is it is not an emergency. My client's already exercised parenting time. And as I set forth in my brief, the defendant was aware of all these issues when she gave my client extended parenting time. As I also set forth in my client's responsive declaration, that he's been stalked by the defendant and or her relatives to try and catch him drinking. He's been photographed, he's been followed, and this motion is not set, it does not set forth an emergency. I mean, it's been months in the making. They just waited for an incident to put it into place. So I'm going to kind of give the court the timeline. On the 18th, he did not get his son. On the 19th, he went into treatment and he went in to adjust his depression, anxiety meds, got blood work done. After that, he's been back at work. It's as usual. He doesn't need to have a psychological evaluation because he's treating with his treating professional. He doesn't need to get an alcohol evaluation because he's currently in therapy and in treatment. I don't know what more he is supposed to do. He doesn't need to be on supervised parenting time. His fiance, and there are no allegations that she has any alcohol issues, lives with him. So in a sense, his parenting time is already supervised because she's right there with him. So I would also point out, Your Honor, Mr. Johnson did not contact me regarding these things. He would have been told the state of things, and instead he just fired off this ex parte motion because They'd been planning to do so for months. I don't see a reason why it's in this child's best interest that suddenly my client doesn't have joint decision making. And I don't see why it's in this joint child's best interest to not have the extensive contact he is used to with his father. And by the way, my client went into treatment and he sought therapy and he went to get his meds adjusted the day before he was served with this ex parte motion.
Thank you. Ms. Lindberg, I do have one question for you. How do you view the motion that was filed in this case in light of Rule 8.2 sub C and North Dakota Century Code section 1409-06.6 and Rule 8.3.1?
Well, as I said in my brief, I don't think he's got the basic grounds. I mean, she's got primary residential responsibility.
She has primary residential responsibility. So, but her motion is asking for sole. So it's not primary, but it's sole residential responsibility. So is that a type of motion that modifies residential responsibility that also must accompany or be accompanied by a motion to modify residential responsibility under 1409-06.6? So which standard am I going under? Am I going under 8.2A or am I going under 8.2C, which says that the motion is not valid unless it's also simultaneously filed with a motion to modify residential responsibility, and the standards are different between A and C. So is this an 8.2C motion or is this an 8.2A motion? It's unclear to me which standard I should apply. And that's not something you addressed in your brief. I think you addressed in your brief in response to an 8.2A motion, but I don't know if that's where it technically should fall in light of the relief that's being sought. What's your position on that?
I'm trying to get the rule up in front of me, Your Honor. I would say C. Because he bolded the sole residential responsibility.
All right, well, and do you have a position on whether or not he filed a proper motion?
No, I don't think he did.
Seeking to modify residential responsibility under 1409-06.6?
No, and I think that's wherein I got a little confused too, because he doesn't even have the basis under 1409-06.6.
All right.
I mean, the child has never been harmed.
Well, it's A or B and C. So A and B are alternatives, and C, and I should be clear, under subsection C of Rule 8.2, subdivision 1, there are 3 requirements, A, B, and C. And in order to have a basis for the motion, the court can consider entering an interim order to modify residential responsibility if one of the first conditions are met and condition 3 is met and 1409-06.6 if a motion has also been filed there. So you have to file a motion, and then you have to establish that either there's a threat of imminent danger to the minor child of the party, or there are present circumstances indicating that an interim order is necessary to protect the minor child of the parties. So it's one of those two. And there has to be good cause to set a hearing on a shorter time frame than under Rule 8.3.1. So you have to show one of the first two plus number 3. Is that your reading of the rule?
Yes.
Okay. And your argument is he hasn't shown either of the first two, and he didn't file the necessary motion under 140906.6.
Yes.
All right. Anything else, Ms. Lindberg?
No, Your Honor.
Well, the court has considered the motion. I also find it to be an 8.2 subsection C type motion in light of the relief that is being requested. The court notes that there does not appear from the court's review of Odyssey that a motion was filed to modify residential responsibility under 140906.6 and Rule 3.2. The court also finds that there have been no allegations directly that the party's minor child has been harmed by the respondent here. And then when I say respondent, I mean non-movement. I mean Mr. Mullen here. So then the question turns whether or not the declarations or affidavits contain sufficient evidence to establish that circumstances exist that would warrant the issuance of an order to protect the party's minor child. Here, arguably, the DUI, or at least the allegation of drinking after the DUI at the hockey game, which again is largely hearsay and is largely non-competent declaration information, the court finds that insufficient to meet subdivision A or B of subsection 1 of subpart C of Rule 8.2. The court also finds that the motion itself does not comport with the requirements of 8.2 C2, which include a notice provision that must be included in the motion. Because the technical requirements were not met, the court, even though Mr. Johnson isn't here to articulate his position, are hereby denied. Ms. Lindberg, I know it's Wednesday afternoon before Thanksgiving, but I'll ask that you prepare a brief order explaining the court's decision. Serve it on Mr. Johnson. Explain we attempted to have the emergency hearing. The court found that the motion was of the type under 8.2C, that the motion did not meet the technical requirements, nor did it meet the substantive requirements of either A or B of C1. And for those reasons, it's denied.
Would you like that filed today?
I would like that filed at your earliest convenience. If you can get it done today, that explains to everyone what happened. If it doesn't happen until next week, that's not going to cause me huge heartburn. Nevertheless, that's as soon as you can. I understand it's late in the day and it's also right before a holiday. I also understand that although I'll be working on Friday, that doesn't mean that most people are going to be working on the Friday after Thanksgiving. Nevertheless, the courthouse is open, so if you file it, someone will receive it and I will sign off on it. Get it to me as soon as you can, okay?
Okay, thank you, Your Honor. It probably won't be until, I'll get it to you for sure on Monday, if that's okay. For sure on Monday,
That's okay.
okay? Because
It's
I'm technically starting my Thanksgiving tonight. So
understood.
I waited for this hearing before I could leave.
Well, you're already looking awfully fall colored, so enjoy your Thanksgiving, and we are adjourned.
Thank you.
Okay. I agree with this attorney because this is ridiculous. They're following him around. Somebody catches him at a hockey game. They might live in a very small town, so it's easy to run into people that you know. Maybe, I don't know, but they catch him at a hockey game having some beer. Some. Not even a whole one, I don't know. I don't know. Maybe it was just a sip, for all I know. For all we know. And for that, they want to take away any custody that he has. Any time that he gets his son. So I think Mom is trying to make it impossible for Dad to do anything. She's going to make it so hard that she's hoping he will just give up and go away. Just make sure he sends the money. That's what I think. I think she's going to try to make it so impossible that he will just give up and go away. But this is the best time to fight for him, for his son, because what will end up happening is the things that she's doing to undermine Dad will be shown, and then he will end up with the custody that he wants. That's my opinion. So that's what I think. I'm so glad that this judge saw through what that was. And it was just it wasn't about the son. None of it was about the son. It was about control, and you'll do what I want. That's what I think. Anyway, thank you guys so much for watching, and I'll see you another time.